It's my great honor to welcome and introduce Justice Stephen Breyer. On the assumption that his credentials as an Associate Justice of the Supreme Court of the United States for more than 20 years are well known, I would like to focus on a few aspects of potential interest to the present audience. During his time on the Supreme Court since 1994, he has been one of several justices who have spoken out to make the case for why international, foreign, and comparative law are relevant to different aspects of the court's judicial functions, including but not limited to giving meaning in the present era to the words and concepts of our 18th century Constitution. Indeed, today he makes a repeat engagement for an ASIL keynote lecture, having spoken on those themes in a well-attended and much-noted address at our 2003 annual meeting. In a somewhat smaller but still significant setting, he returned to our annual meeting in 2012 to make a very special introduction at that year's Women in International Law lunch, which featured Professor Mireille Delmas-Marty, a prominent French academic. Those of us present could appreciate Justice Breyer's cosmopolitan qualities manifested in his French language skills on display on that occasion. For further evidence in that regard, may I cite the interview published under the title "On Reading Proust" in the New York Review of Books with this editorial note, quote, "The following interview with Justice Stephen Breyer was conducted in French by Johanna Kohler and was initially published in La Revue des Deux Mondes in Paris as part of a special issue entitled Proust Vue d'Amérique. It appeared in the New York Review in translation. In response to the interviewer's first question about when he first read À la recherche du temps perdu, he explained that his first encounter with the recherche was when he was working as a legal intern at an American law firm in Paris. He worked his way through all 7 volumes in French by drawing up vocabulary index cards at night. If you are curious about Justice Breyer's views about, say, the relative absence of lawyers from Proust's writing or the place for the Dreyfus case in the recherche, please read that interview either in its original French or in the New York Review's English translation. Last year, Justice Breyer published an important book-length treatment of topics that have occupied his attention for a very long time. We are delighted that he has agreed to discuss with us that work, The Court and the World, American Law, and the New Global Realities. I now give the floor to Justice Breyer.
Thank you. Thank you. That was a very nice introduction. I do remember that summer when I was in law school. I was working for Lee Hudson, who was the son of Manley Hudson. And the nicest thing about it really was nobody started until about 10 in the morning, and various young women came through with refreshments throughout most of the day, and we had quite a long lunch. And we wrecked French civilization because one of the jobs I had at the Cleary Gottlieb firm was to help work on a contract that was going to create a frozen food enterprise somewhere south of Marseille, I think. It was probably in the ocean or in Algeria. That was the end of French cooking, you see, what you brought bird's eye in. But I'll say only one of the, it is a hobby, French, and what my wife says, some of you speak French, she does, she says, Washington est jonché avec les victimes de mes efforts de parler français. Now, for those of you who don't speak French, Washington is littered with the victims of my efforts to speak French. That's certainly true. But I'm not going to talk about it. I'm talking about this book, which has the unpretentious title of The Court and the World. Why did I write this book? I don't know. Stop me before I write again. But the reason, I think, basically, it's a kind of report. I mean, you are the specialists in this area. And I want people, but I want you to help us. And what I want is to talk to other people, to tell them that what you're doing is relevant to what they do. And I want to talk to you to tell you, please, help all these others. And the best way, I think, to do that is to give a kind of report. It's a kind of report from the front. You see, I'm not suggesting anything. I'm telling you what we do. And when I started 20 years ago, there would be an occasional case that required knowledge of some other law or international law. Today, that's much more than occasional. It's gone like this. And I think it's 15 or 20%. And very often, the information isn't there. Or at least we don't know how to find it. Or at least, you understand? It's sort of like this. I hope you know, the Charterhouse of Parma. In the Charterhouse of Parma, the hero, Fabrice Del Dongo, he starts off at the beginning. He's wandering around Waterloo. And there are bullets going all around here and there, and the horses are racing back and forth, and there's fog, and Napoleon is riding his horse and comes up and runs away. And what Del Dongo is thinking to himself, he says, something really important is happening here. He says, I wish I knew what it was. Now, that's how many of us feel about when we hear these words, globalization, interdependence. I mean, yeah, I got it, but I don't. I mean, what's it actually about? And so I can't tell you the answer to that, but what I can do is illustrate what's going on under that rubric in our court over the last few years. And so I break that down and try to explain to people the kind of cases we have, and I hope that they'll draw the conclusion that they draw this conclusion anyway, that we ought to have a lot more knowledge than we have. They draw that conclusion in most of our cases, but they're too polite usually to say it. But anyway, what kinds of things? I'll give you a few examples. I mean, take what is a big question of great general interest. How are we to weigh interests in national security versus statutes or laws or practices that infringe on the traditional area of civil liberties in the name of protecting security? Now, there are far fewer cases on that subject than you think. That's what Justice Jackson said in the Steele seizure case. He says, you go back and look and see what the law is on the power of the executive in this kind of situation. You will discover it's, see what the founders thought. It's like Joseph being asked to interpret the dreams of Pharaoh. That was a good line and quite true. I mean, why? Why are there so few cases? In part because judges for many years, including judges here, for decades, followed Cicero's advice. I mean, Cicero said, well, I used to translate it this way because I don't really remember any Latin. When the cannons roar, the laws fall silent. Now, before you think that's a good translation, remember that somebody raised his hand and said, the Romans didn't have cannons? But still, you see the point. Well, that was what they followed, including us. Go back and look at the Civil War. Go back and see what Lincoln did and what the Supreme Court did. Nothing during the war, nothing. And the Secretary of State, Seward, called in the British ambassador and he said, you see, that bell there? He said, I can push that bell and have any person I want in New York State thrown into prison. I can push this twice and I can have anyone I want in Indiana thrown into prison. Tell me, he said, does the Queen of England have such power? Well, the court did get around to deciding cases involving that kind of thing after the war was over. Read the history of Wilson in World War I. Remember, Learned Hand's case, the masses. I mean, there are dozens of them. What happened to free speech? Well, I don't know. Something happened to it, but there wasn't much in the court at that time about it. And now jump to World War II. And what do we find there? We find 70,000 American citizens of Japanese origin put in camps, moved from their houses on the West Coast, and put in camps because General DeWitt thought it was a good idea. I mean, I was alive then. I was small, but nonetheless, I can remember blackout curtains. He was afraid San Francisco would be invaded. And people did think that might be so. But he said, I'm sending the Japanese because there have been 735 instances of signaling to submarines offshore and 5 instances of sabotage, so forth and so on. Anyway, one, Korematsu, contrary to his parents' advice, So they can't do this to me. I'm an American. I haven't done anything. And he got a lawyer, Ernie Bezic, who was the lawyer for the ACLU. And by the way, at the beginning, the ACLU would not support him in this case. But that was right in World War II, you see. You get the idea? Eventually, they came around. Korematsu was certain he was going to win. He got to the Supreme Court by 1944 when there was no risk of invasion at all. None, zero. I mean, no one thought we would be invaded in 1944. Two lawyers in the department, Ennis and Burling, went and they got suspicious of all of DeWitt's figures, and they called in the FCC and said, what were those 735 instances? I mean, what was this Sabbath? They came back, the FCC people, with a stack of stuff like this in about 2 weeks and said there weren't any. There were buck-pot privates. They didn't know how to work the equipment. You did a good job. J. Edgar Hoover said there was no sabotage that we can handle. There's no need for this. The person who wanted it, Earl Warren. And he said it's one of the worst things I ever did. But he was for it. Hoover was against it. Ennis and Burling discovered there was no evidence because they asked, how did you do this so quickly? Discovering there was no evidence of any signaling or anything. They said, oh, we didn't do it now. We did it in January of 1942. And we showed it to General DeWitt at the time. Well, they wouldn't sign the brief. They wouldn't sign it. But then the Justice Department called in somebody who was very good at negotiating, and he was head of their war section, and that person's name was Herbert J. Wexler. Now, most of us know who that was. And he wrote a footnote that he got them to sign. He got them to sign the brief, and that footnote was so obscure you had to read it 10 times before you realized that it said that the Justice Department disowns DeWitt. The Justice Department thinks there is no evidence really here. They had to have some argument, I don't know what it was, but it said that, if you read it very carefully, 15 times. So for a long time, I thought nobody on the court had read it. Then I read the transcript of the argument. And I'm using these names because they're familiar to some of us. Charlie Horsky, the lawyer for the Japanese American Defense League, told the justices, read that footnote, and you will see there's no evidence at all. Indeed, there wasn't. And who did the court decide for? Not for the Japanese. It decided in favor of the government, 6-3. The three being Jackson, Murphy, and Roberts. And why? Well, I suspected it, but somebody who knew and had read the conference, what was going on at that conference, told me that's absolutely right. Black walked in. I mean, who was for the government? Black, Douglas, Frankfurter. I mean, you know, the real civil libertarians. Black walked into that conference and he said, somebody has to run this war. We have to do it or Roosevelt, and we can't. That was basically the argument, you see? And you see where it led? All right, now I'm mentioning all that history because I want to show you the change. And I think the change begins, and Cicero is gone, with the Steele seizure case. And if you want to read an interesting case, read it. I mean, by then, the court was brave enough to say, Roosevelt, you're wrong. You're trying to seize the steel mills to help the soldiers during this Korean War. And they felt they could stand up to Roosevelt, particularly because his name wasn't Roosevelt, it was Harry Truman. And he was very unpopular. Therefore they did. And they said, no, you've gone too far. We won't let you seize the mills, even though it's wartime. And now we have 4 Guantanamo cases, and in those 4 Guantanamo cases, in each one we decided in favor of the detainee. The detainees are not popular. One was bin Laden's chauffeur, not a popular man. He was standing up against, on the other side, some of the most popular officials in the world. The president, the secretary of defense. He won. He won, and the court said the law, the statute, that says that detainees cannot come into federal court to complain under a habeas corpus is unconstitutional because you can't suspend habeas corpus in these circumstances. But in each of the 4, the detainee won, and the key to that 4, and why I think this is all relevant right now, are the words that Sandra O'Connor wrote in one of the opinions, which I joined, which said, the Constitution does not write a blank check to the president to limit civil liberties significantly, not even in wartime. That's what she said. I agreed. But as soon as you say that, I think 3 seconds later, the following question will pop into your mind. Fine. It doesn't write a blank check. What kind of a check does it write? You see? And that's where we are. And that's what's difficult. What kind of a check does it write? You consider, as I've had to consider, the criticisms of us in that case, in those four. On the one hand, there are those who say, you shouldn't have gotten into this, period. What do you know about security? Nothing. I say, okay, I understand that. And if I follow that approach, I'm back to the Japanese. Well, why didn't you write something that was meaningful? Why did you just decide this little bit of a thing over here? Why didn't you write something sort of broad, or at least tell us whether we can use hearsay and a bunch of other stuff like that? To which my honest response is, because I don't know the answer to those questions. Because I don't know what the rule ought to be, or what the decision ought to be, in a case I have not yet foreseen. So they're pretty narrow decisions when you read them. And the reason I raise this for you is I agree with the first and the second. It would be nice to decide more in cases, or at least to decide the cases, and I don't want to go back to the Japanese, and that means we have to know something. What? About security problems, which are international in nature at the moment, about what other countries are doing, about how other people with similar backgrounds are handling this affair, not because we're going to copy them, but because it at least gives us an expanded field of knowledge. Of course, we can just simply accept whatever the Solicitor General tells us. And I'll tell you what he's going to tell us. I don't even know the case, but I'll tell you what he's going to tell us. Even without knowing the case, he's going to say, this is necessary. That's his job, if he's going to appear in court and defend it. And so we are in the position of not being able simply to accept that, and that means we have to know something about it. And that means the lawyers have to know something about it. And that means the lawyers have to be able intelligibly to ask the question, why do you need this restriction? And get an answer, some of which may be classified. And should that go into the judge without the lawyer present or not? And when and under what circumstances? They'll ask, why not? Even if you need it, why can't you do it this way, which is less restrictive? Traditional questions in civil liberties areas. Why? Why not? I can easily state those questions. I cannot state what kind of legal framework they should be asked in, what goes to the judge, what doesn't, how we find out about what's happening abroad, how we find out about, and if you think that this is going to last, this security situation, then it's important that we have systematic ways of going about this, finding out the nature of the problem and the nature of the need and what is reasonable to do or not to do. Why do we have to do that? Well, we have no security power. That's given to the president and the Congress under the Constitution. But we do have a power to protect basic civil liberties. And so I'm back to the beginning. I'm back to the beginning, asking the question, and how do we balance that? No blank check. What kind of a check does it write? Does it require us to know something about abroad or not? Of course, I think it does. And you're in a better position than I to know the answer to that one, and I suspect many of you think it does too, and the only question is how, and under what circumstances, and who says what to whom, and where do the lawyers and the law schools and the professors and the judges all get their information from. Now, that's not the only problem in front of us. There are a lot. There are commercial problems. They come up every day. I mean, I love the case we had. The case we had where there was a student from Thailand. This student from Thailand went to Cornell. He discovers that his textbooks in English are much, much cheaper. Same textbook in Thailand. So he writes to his parents and says, send me a few. And they sent a lot more than a few. And he began to sell them, made a lot of money. The publisher got annoyed and got a lawsuit. Brought a lawsuit against him, and the answer to whether they had a lawsuit, winning lawsuit or not, lay in a handful of words in a technical statute, the copyright law, technical words, hardly obvious what the answer is. They're pretty obscure, and they decide whether he's going to win or lose, and I go into my office and discover a stack of briefs like this. And My goodness, there are briefs there being filed by lawyers from Asia, from Europe. There are countries that are filing briefs. There's the EU filing a brief. Everybody's all over the world seems to be filing a brief. I've exaggerated, but not by too much. And I'm thinking to myself, why in heaven's name do I have all these briefs? I'm not complaining, but I mean, that is the job, but still, okay. But why so many and from so many? Because copyright today is not simply a question of books, music, film. It's everywhere. It's everywhere. It's in automobiles. That software can be. Go into a store and look at the labels, copyrighted. And we're told in one of the briefs that the answer to this question about this student in Cornell who sent away from some textbooks is going to affect $3.2 trillion worth of commerce. Well, even today, a lot of money. And we have to have an answer. And again, I think if you look at the decision, you'll see to get that answer, you have to know something about what goes on abroad. You have to know something how publishers act abroad. You have to know something about the laws and the International Convention. You have to know quite a lot. And again, it has to come from people who know the picture across the world and not just within the United States. I mean, there are lots of these cases. Try treaties. And this isn't an argument within the court. Everybody agrees that when we interpret treaties, we look to what other countries do too. And I was rather surprised when within a period of, I think, 2 years, we had 3 cases involving one treaty involving the abduction of children, the Hague Convention. 3 cases on that one treaty. And we're deciding what it means. We do look to other countries. But I do sometimes, we are deciding it? I'm a federal judge. This is a subject of domestic relations. Domestic relations judges really have a hard job. I mean, I have a couple of friends, one in Cambridge, one in England. They tell the client the same thing. They say, you decide yourself and reach an agreement, because if you don't, I'll have to decide, and it's going to be worse than anything you decide. I mean, and that's terrible, terribly difficult. And who knows less about it? Other judges, and who knows least of all? Federal judges. They don't have these kinds of cases. But why do we have this? And what do we discover in those cases? I mean, there's a group of people who are very much against abduction. They got part of this written, and they go around to different courts and say how it should be interpreted. But all of a sudden, on the other side, are people who are equally strongly against spousal abuse. And those two things are connected. And the spousal abuse people don't want often the interpretations the others want, because they think abduction is a response, quite often, to spousal abuse. Well, we're there, left deciding that. And why? Do we have to decide it? Because it's in a treaty. And why is it in a treaty? Because today, marriage is more and more a matter that transcends national boundaries. That's why. And so it's not going to be just for the domestic relations judge in Cambridge. It's going to be the subject of a treaty, and we have to know how to do it, and of course we have to see how others interpret that treaty. I mean, I'm simply saying it's all over the place. You know very well the case of Dolly Phil Artiga. I'm sure virtually everybody in the room knows that. Paraguay, she comes to New York. She finds the man, also from Paraguay, who in Paraguay tortured her brother to death. She brings a lawsuit under the Alien Tort Statute, a law written in the 1790s, probably in part to protect victims of piracy. She wins. And it says you can recover for injury suffered by a violation of the law of nations. That's Congress saying that. That isn't reaching out to decide something that's happening in Tasmania or something. I mean, that is, in fact, right there in the statute. What is it? What does it mean? To whom does it apply? Who are today's pirates? Filled with difficult questions. And we've heard it twice under Sosa and in this Kiobel, and it's not, I think, perfectly clarified. Not even yet. But you see the kinds of problems. My goodness. I mean, why are people so often so hostile to considering foreign courts? I mean, I think in part it's because what Madison said. Madison said that our Constitution is a Constitution that where liberty delegates power. Power doesn't delegate liberty. And what he meant by that is, unlike King Louis XIV or any royal presence in England at that time, or France, or in a foreign country, where the power's in the center, and they might delegate freedom to people, but the power is in the center. Here, the power is with the people, and they delegate the power up to the Congress. And if Madison thought, he thought, if it isn't delegated, you don't have it. You see? Power rests in the people. Does that survive today? Oh, it sure does. And when I'm talking about referring to foreign countries, I often get some response where I know where that reaction is coming from. Who are those people? And it isn't just a kind of chauvinism or narrow-mindedness. It in part reflects what Madison saw, that we're the people who have the power. We delegate it to the president. We delegate it to the Congress. We let them do a lot of things, and the judges are at least pointed by them, if they're American judges, but who are they? Where we had no say whatsoever. And that is an attitude that I think can't just be brushed aside. I think it has to be met with argument and reason and understanding as to why they might want to accept a decision, or at least look at a decision that's made by a group of other people. And that's much harder to do than one might think, but I think it's an important thing. So go back to the Alien Tort Statute. You have a problem of legitimacy when you start looking to what the International Court of Justice is doing, namely the problem I just mentioned. You have a problem of interference. South Africa files a brief in one of those cases involving apartheid and says, we don't want American judges deciding that kind of case in South Africa affecting us. We have our own methods, truth and reconciliation. That's our method. And the judge in New York knows nothing about that. We want him out of it. That's what they said. Does that mean we immediately get out of it? Or what? And there are problems of universality. After all, if we can do it, they can do it. And if we're going to go after torturers, they're going to go after somebody else. I mean, normally when you read an article about this, they're always trying to put Henry Kissinger in jail. I don't know why poor Henry Kissinger. But you see the point? Where, what, careful. When we're deciding something, be sure it's universalizable. Be sure that if other people follow the same system in other countries, we can today find a system that works. Lots of cases involving antitrust, involving securities, involving a host of things, involve that kind of principle. Or go look at international organizations. I was very interested in finding that Professor Cassese sent all his research students to work, and what they discovered, I never knew this, you probably know it, ask this question, ask how many organizations there are in the world where a group of administrators, kind of bureaucracy, in fact has the power to make a rule, call it a rule of law, something like a rule of law, that binds people or businesses in more than one country. I mean, here you'll have a no. The answer is something over 2,000. And we belong to nearly 1,000. I mean, you've heard of them all, but I mean, most audience I speak to or people who read this book, they won't know. I mean, they know the United Nations, they know the World Trade Organization, they don't necessarily know the Bluefin Whale Commission, they certainly don't know the International Olive Oil Council, but they're important, a lot of those things. And they make rules. And what's the status of those rules? And how are we going to reconcile that with the Constitution that says Congress has the power to legislate? Does that sound familiar? It sounds like the New Deal. Yeah. What's an agency? And we have cases, Crowell and Benson, famous cases, that go into that effort to figure out how you can have such a thing as the International Commerce Commission, or the Interstate Commerce Commission, and what the role. We had an Administrative Procedures Act. And what's going to happen to the Bluefin Whale Commission? Or these others that seem to have the Berne group. What's that group in Berne? All the regulators and the banks all meet to work out sensible rules for regulating banks and finance in many countries. And then they work it out, and then the SEC people come back home and they promulgate an identical rule. And the people who are supposed to have it, well, they can comment on the rule, they can comment and participate in its creation. Before the SEC. But where was it really created? And what chance do they have once there was an international understanding that it would be the Rule X, which now the SEC says, come and comment on our proposal to have the Rule X. Okay, I get it. Maybe not too meaningful. See, people are making those kinds of arguments. They're beginning to make them. They're seeping into the courts. And if we say, though there's no power for Congress to delegate to the International Bluefin Whale Commission or any other group the power to legislate, how do we solve today's problems and tomorrow's? How do we deal with problems of environment, with problems of security, with problems of commerce, with problems of health, which are more and more international problems? We have to be able to delegate. I mean, if you can't, the world will go on without us, and we'll suffer anyway. So we're better off participating. But then how do we participate, and in what way? And how do you reconcile those kinds of things with requirements, say, of the Administrative Procedure Act, let alone the Constitution of the United States? And other countries are facing this problem, exactly the same kind, or very similar problem, when the German Constitutional Court has to decide to what extent does our German Constitution allow us to delegate to the EU the power to set rules, i.e. pass laws. Italian Constitutional Court, Austrian Constitutional Court, all decide the same thing, all decide the power is not unlimited, but nonetheless, none of them's ever found a case where they said they couldn't do it. But still, all right, you see, I'm trying to illustrate a kind of problem that is either there or will be there in all likelihood, as long as we have hundreds, maybe thousands, of international organizations that are in practice making laws. And the one that makes the most of the laws that affects you every single day, and me, and maybe changing, but nonetheless, nobody's ever heard of it, or very few. ICON. What is ICON? ICON's in Los Angeles. ICON's a kind of company or some sort, incorporated under California law. And it makes the rules, apparently, governing the internet. And what's its status? And what happens if people, you understand. All I'm trying to do is show there's a problem. And I'm trying to describe in enough length that people will begin to understand what that problem looks like as seen by a judge of our court, which is a kind of narrow prism in a narrow area, but does illustrate and give concrete meaning to the term interdependence and globalization that we see every day, though it gives that meaning only in one narrow area. But my hope is, of course, that people will look at it and begin to speculate and begin to answer some of the questions raised. Well, why is that so important to us? I think it's very important to us. I think it's very important to us. Because what governs a lot of these things is it's a little corny, but I think it's absolutely true. I mean, the corny thing that my wife paid each of my grandchildren $20 to memorize is embodied in the Gettysburg Address. The question that we ask the grandchildren and get them interested in this. See, Lincoln says 77 years ago, our fathers called forth upon, I'm not going to remember, called forth upon this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal. We are now engaged in a great war to determine whether that nation or any nation so conceived and so dedicated can long endure. It's an experiment. That's what the founders thought. And at the time they wrote that Constitution, there was no place like it. I mean, it was an experiment. And he refers back to the Declaration. That's what happened 77 years ago, not the Constitution, because it contains the words, all men are created equal, which the Constitution doesn't. And so we've changed. We've brought many more people in. And now when you say, who are we in America? The answer to that question is going to be very different from England. England or France are places where, after all, they say, well, we're not descended from King Arthur. We're not all descended from Clovis the Short or Pepin the Bref or whatever it is. We're not. There is no tribal leader of ancient legend. What we have that brings us together is that document, the Constitution. That's part of it. And that's an important part. So that people of very different views, of very different races, religions, backgrounds, all kinds of things, nonetheless find it a common enterprise. You see why I find that important in this context? Because that common enterprise means that we have to show that that system, which does bring people together in that way, can help to work to solve important problems in the world, which we've mentioned, we all know, security, environment, da-da-da. All right? And that's what I think is at issue here. And I think that we are trying to show to those skeptics that we can do it. We can help. We can help through democratic processes protective of basic liberty, but that's who we are. And I think it's awfully important for us to be able to do that because probably part of my job, but I think that's what the rule of law itself means. Okay, that's why I wrote the book. Now you've heard enough of it to see that it raises questions and it answers none. Thank you.
Justice Breyer has just told us that the book may not answer your questions, but he has very kindly agreed to take some of your questions, and maybe he will answer them, and then we'll go to the gala reception, and he might sign a few books for some of you. But he will take a few questions, so maybe 5-10 minutes?
Sure.
Yeah, go ahead. So,
you have to call people because I can't see.
Okay, all right, please, someone come to the microphone. It looks like Professor David Sloss is coming to the microphone.
Good afternoon. Thank you very much for that wonderful statement and speech. We really appreciated it, and I think I can speak for everybody here in saying that. So I was interested in your account of sort of the tension between liberty and security. You gave a historical account that started with the Civil War. But actually, if you go back to the founding and you look at the 1790s and you look at the War of 1812, there's some interesting precedents there for some of the modern stuff that we're dealing with. And I think those tend to get overlooked. But the court actually played a pretty active role in wartime, both in the war between France and Britain, where we were put in a position of kind of a mediator in some cases, and the court actually dealt with a lot of those cases. And in the War of 1812, the court dealt with some cases. One case where, well, this isn't the Supreme Court, but actually a lower federal court granted a habeas petition on behalf of a bunch of foreign national detainees who happened to be British, but they were still foreign national detainees. So, I think if we go back pre-Civil War, there's some interesting...
Did the Alien and Sedition Acts ever appear in any court?
The Alien Sedition Act?
Yeah, I wondered that. I'm asking that as a serious question. I didn't find much reference to it, and I didn't really look back much before the Civil War, so it's reassuring what you say. But do you know the answer or not?
I don't know the answer to that.
Yeah, all right. But
So more research to do.
all right, well, thank you. Thank you for the comment. Yes.
Good evening, Mr. Justice. I'm John Washburn, the convener of the American NGO Coalition for the International Criminal Court, and I was naturally exhilarated to find in your book certain positive references to the court's decisions and legal positions. But I thought that before I went out and said to my opponents in our advocacy, hey, look at what the judge has said, I ought to ask you, do you confront the argument that because the court the U.S. is a non-state party to the court, that therefore it's impermissible to use legal positions and decisions taken by the court in American courts?
No. That is to say, when you say use them, I mean, my own view, and here, you see, there is a political question. It's not really a legal question. I mean, I don't think it's much of a legal question. The question is, should we refer to decisions of other courts outside the United States? Now, my view has been you can read what you want. They don't bind us. But we read all kinds of things. And so where you have a person with a job like mine, who has a document somewhat like mine, and say he makes a decision that seems quite relevant to some problem, why don't I read it? It can't hurt. I don't have to follow it. Now, I thought that was a great argument. I made that when I was on a panel with a congressman who was thinking the other side of this, you see. And I thought and he was criticizing doing just what I said. And I made that just what I said. I thought, wasn't that a great argument? So he says, fine. He says, read it. Just don't refer to it in your opinion. So that, not knowing, you know, most members of Congress and other people in public life actually have a very great deal of experience in how to deal with difficult arguments, and they do it pretty well. So instead of quitting while I was ahead, I said, yes, but there's more than that. I said, you know, there are a lot of countries, quite a few countries, that are now democracies that previously weren't. They have independent constitutions. They try to guarantee people basic rights, and they have independent judiciaries designed to help in that respect. And some of them aren't respected very much by their legislatures who try to cut their pay or do various things. And if we refer to them, they refer to us. That might help a little bit. You know, give them we've been around a long time. Maybe it adds to their prestige or says to somebody that they're important or something, and that'll help them do their independent job. Well, he said, fine, write them a letter. So I thought this was pretty smart, actually pretty good. So I said, well, what is it? So then I said, well, I sent him a copy of this book. I said, I wrote it because I want to convince you. And it seems to me that the best way is not to make some kind of argument, but just to show you what is actually in front of us. And when you see what is actually in front of us, my hope is that your concern is really a concern which is a legitimate one. It is a concern to preserving American values. And of course I understand why. It worries you if we're talking about foreign cases all the time. But I think if you read what's actually in front of us, you might come to the conclusion that the best way to preserve American values is to know what's going on elsewhere in the world, which often involves reading things that come from foreign sources. And that the world will go on without us, as I said, regardless. And it's better for us to participate or not than not, if we want to preserve the very values you want to preserve. So that's the argument of the book.
Thank you, sir.
Mr. Justice Breyer, Brian Murphy, longtime admirer of you, sir. Simple question. Have your 7 colleagues read the book as I've read it, and are they convinced?
I hope so. I hope so.
And Merrick Garland?
I hope so, but I don't know who's read it and who hasn't read it. And the best thing to do is, above all, if you write a book, you know the worst thing to do? The worst thing if you write a book? Look at Amazon. Don't do it. So I rarely ask who's read this book. If someone comes up and tells me he has, I say, you are a valuable man. But the point is that on many of these questions, there is no division of opinion on the court. I mean, in many of these questions, for example, treaties, everybody's going to look to what other countries say. In the securities case, or where you're trying to interpret a statute that's passed by Congress and determine its limitations, everybody's going to read those briefs that are filed by not just Australia, but also by the EU. And everybody's going to think they're relevant. The opinion in that case was written by Justice Scalia. And it referred to what the arguments were made by some of these other countries and found them useful and meaningful. All right, so on many of these things, there isn't that much of an argument. On some there is. I mean, the ones that have caused a lot of dissent and often used in political forums are those involving the death penalty and gay rights, and that's understandable. Those are controversial cases. But you don't have to get into, I mean, you can step around those controversies. Yeah. Yes.
Thank you, Mr. Justice. Mark Wojcik from the John Marshall Law School in Chicago.
Yes.
Do you believe that the Senate confirmation process, when they could ask candidates about their views on citing foreign and international sources?
Well, normally, yes, the Senate confirmation process. I answer a lot of questions over the years on the Senate confirmation process. And usually what I say is asking me about the confirmation process. I was the confirmed person, not the confirming person. It's like asking for the recipe for chicken a la king from the point of view of the chicken. Now, given the present circumstance, see, that is a clever way of sidestepping the question, so I don't have to give an answer. But it seems to me, given the present situation, the only way I can not answer a question is be quite honest and say, I'm not going to answer any question involving the Senate confirmation process, no matter what. So I'm sorry. There we go. Yes.
Justice Breyer, thank you so much for everything. I have a very specific question. Internationally, many constitutions have incorporated the public trust doctrine into their constitutions. When thinking about the public trust, do we just need to look till federal law because we arguably have a federal public trust doctrine, or do we need to look internationally at what other people do as well?
I don't know.
Okay.
I mean, that I honestly don't know, because you're already, remember, you are the people in this audience who know the technical features of almost all of these things. I know them when and if they come up. I see them as from the point of view of a generalist. I am a generalist judge, and so I'm heavily dependent upon the briefs that are filed and upon the arguments that are made. So, and I couldn't even begin to answer that question until we had the arguments in front of us. I do think, since many of you are teachers, that our profession really has those three parts: the judges, the practitioners, and the teachers. And I think it works well, perhaps in interpreting that question, or other doctrines, when in fact judges do their best at what they're supposed to do. They decide cases. The teachers and professors get a hold of these opinions and they criticize them. That's their job. And they line them up with others. And it used to be called writing a treatise. And they sketch out an area and say it ought to go this way or that way. And the practitioners read that. And when they read it and find it useful to their case, they will bring it back to the judges. And the judges will see the articles through the filter of the practitioner. And we hope, next time we'll do a better job deciding the case, which will then be back in the hands of the professors. You see, it's circular. And I think it works well. And my hope is that by making very clear that the judges are not only willing, they must understand what's going on here. That will encourage the teachers, who will encourage the practitioners, who will teach the practitioners how to look up things that take place in other countries, and we will then eventually receive the benefit of that in the form of briefs and argument that refers back to what the teachers are doing and prior decisions of the judges. Oh, someone over there I didn't see, I'm sorry.
It's an honor, Justice Breyer. My question is this, and I think in reading your book and in your epilogue specifically, you talk about basically comedy and parody, and this as in terms of the rule of law moving forward for diplomacy reasons. I'm wondering if you could comment on taking that a bit further in terms of parity of nations. I feel like you're saying it's inevitable that we must become must be internationalist, but can we take it further to say that in a crisis of diplomacy, deferring and or communicating with other nations for diplomatic reasons could be, I feel like in my lifetime we're at a point of crisis here where this isolationist argument has once again sort of bore its head, and after seeing much progress, and can we use that as in a diplomatic role?
I have to sort of stick with what I know. I don't know diplomacy. I'm not a diplomat. And thus I feel my point has strength when I'm referring to a matter where there is or is most likely to be some kind of an American rule in a statute, or a constitutional problem, or a treaty, or perhaps a rule made by a treaty-created organization that will have application in America. And I'm showing there are lots of problems like that. And in respect to that, that leads us to become involved in other things, and we have to, in order to solve the problem. And I can add, which I've already said 3 times, that if we just shut that out, the world will go on without us. And we'll be stuck with the result. Now, I can say that with some assurance after 20 years of experience with these cases and things. I might not be right, but at least I have a basis in my own experience and understanding to make those assertions. When you start talking about what we should do as a diplomat, I have to say, my word is no good, no better and no worse than that of any other person, and probably might be a little bit worse than a lot of people here who have experience in that area. See how many ways I have of not answering a question?
So we can let you off the hook anytime you want to be let off the hook. If you're gonna, okay, all right. He's signaled that he's headed.